Welcome to those of you who are entering the webinar. We will wait a few minutes to give enough attendees a chance to arrive before we begin the program. Thank you for being here. And again, if you've just arrived, we're going to wait a few moments just to let all of our attendees get here before we start the program, but thank you for being here. All right, it seems to be leveling off a bit, so I'll go ahead and begin. Hello, I'm Hanson Tipton. I'm serving as president of the Knoxville Bar Association for 2020, and I'm pleased today to welcome a guest for our town hall, Chief Justice Jeff Bivins of the Tennessee Supreme Court. Thank you so much for joining us today, Chief Justice Bivins, and thank you for the work that you and the court have done to keep the courts of the state of Tennessee open and to keep our justice system functioning during these obviously challenging times. And Chief Justice Bivins, before we get to questions from our members, can you please give us a brief overview of this most recent order from Tuesday entered by the Supreme Court and how we got here?
Yes, I'd be happy to, Hanson. Thank you. It's very good to be with you too. I appreciate the opportunity. I was very sorry we weren't able to get together for the annual dinner as we've had for so many years, but certainly under the circumstances, we didn't have any choice at that point. Particularly, hey, we didn't get to hear Coach Barnes, but I thought, now let me go, if you don't, I'll go ahead and actually start by giving you kind of a little bit of insight as to the history of how we got to where we were and how we first started out with the initial order. That was the initial order being on March the 13th of 2020. As you folks may recall, during that time period, that was just about the time that the positives started showing up here in Tennessee. They had just begun to do that. Some states were starting to see that. And we had our judicial conference scheduled for Murfreesboro, Tennessee, that was to go from March the 10th through the 13th. We had some discussion about whether to proceed with it, but at that point in time, we made the decision to go forward with it. And in hindsight, we're very glad we did, because what happened was literally during that conference is when all the shutdowns started to take place. And indeed, some of you that are sports fans may recall that one of the triggering points of that was Rudy Gobert with the Utah Jazz testing positive on an NBA team, and they stopping that. And then it was almost like a domino effect, including the SEC basketball tournament that started there. And then it all started happening very quickly. And this was transpiring while we were there. We saw, of course, the immediate need to try to do something with regard to our courts, and with the overriding concern being we had to find a way to keep the courts of the state of Tennessee open, for at least for emergency matters, and for ways to do that. So literally, because we were there with all the trial judges and appellate judges together, it was a true blessing, because we were able to share and go back and forth as to how we needed to approach this and try to balance the aspect of preserving the public health, but yet allowing access, and yet recognizing that each judicial district oftentimes is very different in how they operate and their geographical issues and all those things. So during about a 36-hour period during that time, we had multiple meetings with the judges, and the court ourselves met for long periods of time to come together and work on a draft of what became the March 13th order. And in fact, the final version of that we hammered out on Friday morning, the 13th. And then I literally took it into the meeting, which was our final day of meeting, and read the final order to our judges at that point in time before the order was filed and entered. So with that, we began looking at it, and we were thinking we really wanted to buy ourselves a little bit of time because we had to do things so quickly at that point in time. We wanted to buy ourselves a little bit of time to check out the environment, see what other folks were doing, and do that. So we actually just put down a limited order for a short duration at that point, but we knew knowing that we'd have to develop something more. So then we left after leaving Murfreesboro there. We came back, implemented that plan that was very limiting on in-court proceedings, but encouraging video conferencing and audio conferencing, which we, of course, continue to do today. And unfortunately, I think like most places, we weren't fully equipped to do that at that point in time. So it became a very urgent matter to try to fully equip our judges to be able to have that opportunity to do that. Then you mix that with the lack of access to the actual hardware they needed, plus particularly in the rural areas, the broadband issues that were out there, and access for not only the judges, but even more particularly for a lot of the citizens of the state of Tennessee. So we went through that time period and we issued our second order on March 25th. That expanded upon the March 13th order to a large extent, but kept a lot of that in place, including extending deadlines, addressing what could be held in open court, what should not, but also creating a situation where if there were particular instances where it was an odd instance for a particular jurisdiction, they could contact my office, and we could look at it on a case-by-case basis whether to grant exceptions to that order. And so we've continued kind of that process today. Then that then led to the April 24th order, when we were talking about, this is when we authorized each judicial district to develop their own judicial plans to allow them to open up gradually and start to have a little more in-court proceedings available if necessary. But still, in the meantime, the AOC and the staff there did a great job in trying to outfit our judges with what they needed as far as laptop computers, acquiring Zoom accounts. We had some web access to begin with, but it became that very quickly we realized that we needed more than that. So we moved forward and tried to do that. Are you still hearing me?
Yes.
Okay. All right.
There was a little bit of feedback briefly, but it sounds fine now.
Okay. So we continued down that route, and everyone had to submit their plans to my office, and we went back and forth, and we had very few that we approved first time. We went back and forth and tried to make sure that the emphasis was there still on video conferencing and teleconferencing, but also trying to recognize the unique characteristics of the judicial districts. And just to step back for a moment too, one of the other areas that we realized very quickly that was going to be a problem was our local jail populations. And of course, our court doesn't have control over the state prisons, but obviously we have a lot of direct dealings with the local jails. So what we had required in one of the orders was specifically to develop a jail reduction plan. And that's one of the things I was very I've been very proud of our judges and working with the sheriffs and working with the county administrator, with the DAs and the public defenders and other defense counsel, and everyone jumped on board, and we were able to obtain a 30% reduction on average across the board in the state of Tennessee with regard to our local jail population. And that was done without seeing any real increase in crime either. And it was just a tremendous effort on everyone's part, and obviously went a long way toward helping the local communities deal with the pandemic and the abilities, because as we all know, jails could certainly be a major breeding ground for those things that happen. So as we moved forward, then we began trying to gradually open up more and more. With most of the plans initially, we said only 10 people plus the court personnel in the courtroom. After a while, we loosened that up to say ultimately up to 50% of the capacity of the overall capacity of the courtroom. But that was an upward bar. It still had to be able to socially distance within the courtroom. So if, for example, if you could only get 25% in there and maintain social distancing, that was going to be your limit. So as we've moved forward through that along the lines, and then of course the question of jury trials obviously came up, and it's to this day probably jury trials are our biggest bugaboo in trying to balance the need of going forward with some of these trials, but also recognizing the obvious concerns of the citizens and for jury duty, and trying to make certain that we have the protection there that's necessary for them and the folks in the judicial system. So that in part led to the facial covering requirement that we put in place as a part of our efforts to allow that. And we tried to be very careful and not say that the facial coverings requirement applied to the entire courthouses. What we said was in the courtrooms, and if you are conducting judicial business, for example, in the clerk's office, in the courtrooms, we did not feel like we didn't want to be careful not to overstep our authority, because in many times courthouses have such things as the county clerk, where someone renews their registration for their vehicles and things of that nature. So we try to walk that fine line to do that. There have been some jury trials across the state as we've gone forward. I appreciate the ingenuity and resourcefulness of some of our judges in that regard. In particular, I know in one instance we've had a judge utilize a National Guard armor for jury selection, and then take after the jury was selected to go back to the courtroom. And things such as that are good examples of what happened. But then, unfortunately, as we've all seen, we've seen the numbers continue to rise recently, and we just felt like that we had to take some additional steps at that point. So that's what led to the most recent order that we have. And what we tried to do with that order was, again, balance those situations where we want to leave some autonomy for the locals, but also the need to address the ongoing health issues that are there, which is why we, in particular, did another prohibition on jury trials through January 31st of 2021. There is, we do have a very few trials that are scheduled that are very good. I know, for example, there is a trial scheduled in Madison County on a jury trial scheduled to go during that time period. It's supposed to last 3 weeks. The case is 20 years old, and a products liability, a medical malpractice case. So those type of things, we set up a mechanism for judges to ask for exceptions from me to do that. And certainly we will take a look at those when we get them. But for the overwhelming part, jury trials will not take place in the state, at least through January because of that. We also have been getting a number of complaints from various folks around the state about compliance with the plans and about not observing CDC protocols and things of that nature. So we tried to emphasize how important it was to stay utilizing video conferencing and audio conferencing as the preferred alternative as opposed to in-court proceedings, particularly during this time. And also we reiterated that judges and lawyers both have an ethical obligation to abide by those plans and by the orders that we put down. I certainly realize some folks don't agree with some of the things that are in those orders, but the fact still remains they're there and they're there for a purpose, and we've tried our best to balance what's there. And it's not a suggestion, it's a requirement that these folks follow that. I mean, even to the point of having lawyers show up in the courtroom who have tested positive for COVID, which just is, quite frankly, outrageous. And so we're trying to address those, and we're trying to do that without having to go back to the limited March order that we had, although some jurisdictions all the jurisdictions were given the opportunity to consider doing that, and a few have actually exercised their discretion to go back to that restricted in-person proceedings. So anyway, that's kind of how we got to where we are. Hanson, I don't want to take up all of our time with a monologue here. We can get to questions, but I did feel like it was important to kind of give the history of where we are there, and give an idea about what led us to where we got here, and why, with the overriding concern being we have to keep the system open. And I can't tell you how many times that I've seen headlines that say courts are shutting down, and it's become a pet peeve. A friend of mine who's a lawyer sent me a text recently saying, "So you're shutting the courts down again, aren't you?" And I, in all caps, I sent back, "No, the courts are open in the state of Tennessee." So we're very proud of everyone for making that happen and being allowed to do that. But we still have that obligation to protect the public and the participants in our judicial system.
Certainly. Well, thank you, Chief Justice Bivins. And we will be doing a question and answer format here. I'd like to ask our audience that if you have a question, to please type it in the Q&A box at the bottom of your Zoom screen. Put it there instead of the chat, and we will try to get to every question. We're planning to go for an hour here, and if you have a question that you're not able to get to, please send it to Marcia or me, and we can relay it to Chief Justice Bivins and continue the conversation after the Zoom ends today. We did receive some questions before today, Chief Justice, and some of them may have at least partially been answered by the order that came out, because we've been advertising this town hall for a while now. And so some of these may have already been answered, but we'll just go through these, and I'll try to get to as many through the Q&A box as I can as well. The first question we received starts out: most of our excellent judges and court personnel in East Tennessee appear to be taking the pandemic seriously and following all of the necessary protocols to keep litigants and their counsel safe. However, if we encounter a judge or bailiff who is not wearing a mask or enforcing mask requirements for others, what should we as attorneys do then? What recourse do we have?
Well, that's one of the things we've tried to do, is set up a system where we can address those issues. And we have had a number of those complaints and handle it. And primarily what we have done is designate Rachel Harmon, General Counsel for the Administrative Office of the Courts, as our point person for those type of issues. And when she gets, I mean, obviously, as I step back for a second, if it's possible to address something with the judge, that's obviously the preferred method, and try to shortcut the need to do that. I fully recognize that folks are going to be hesitant to do that, particularly if it's the judge that's not following the requirements. But if at all possible, because hopefully then that will address the problem immediately. If you don't feel like that's a possibility, and you just feel that you have to bypass that option, then contacting Rachel Harmon at the AOC is the best way to go about that. We have tried to, when those type of complaints come in, Rachel immediately contacts either the presiding judge of that district or the particular judge that was involved in courtroom issues, and tries to work it out that way. There have, quite frankly, been a few instances when I have had to intervene and send some not too nice letters to some folks, but those are few and far between to address that. So, and then obviously, if you choose, there are certainly options of informing the Board of Judicial Conduct if it's a matter involving a judge, or the Board of Professional Responsibility if it's a lawyer involved. As we emphasize in this latest order, this is an ethical obligation on both lawyers and judges to comply with these orders.
Related to that question, we have one that came through the chat here that said, can anything be done about bailiffs and police officers who refuse to wear masks within the courthouse? Attorneys are not just exposed within the courtroom. We have to go through security and walk through the hallways to get to the courtroom, and these areas are often staffed by bailiffs and or police officers who refuse to wear masks.
That's a difficult question, obviously. I would certainly encourage the person to take that up with the presiding judge in that area, and hopefully the presiding judge can work with the sheriff's office and do that. That's, once again, in that area, it becomes very difficult because we have to be careful as to what our authority is in that courthouse. We have done as much as we can, and certainly I think it's incumbent upon us to try to move forward. And if the presiding judge is not successful, not able to address the issue, then certainly contacting the AOC and perhaps letting us contact the sheriff or the county mayor is certainly an option too, because we want to do everything we can. Unfortunately, in some instances, we're limited in what we can do, but we will make every effort to try to make sure that the folks are as safe as they can be in that.
All right, and I'm going to try not to jump around too much topic wise, and so we've got some that are kind of related to others. Another one on this same topic is does the Supreme Court have any plans to impose specific sanctions on attorneys and litigants who refuse to follow the orders of the Supreme Court, e.g. those who show up to court having tested positive for COVID-19 and or advised by a healthcare provider to quarantine?
Well, I don't know that we as a court have direct authority to do that, other than to ultimately put down a show cause order and contempt proceedings, and which are cumbersome. But we have not hesitated to refer those matters to disciplinary counsel, in particular to the Board of Professional Responsibility of those lawyers that are doing that. And Rachel and I discuss from time to time when she receives complaints about things of that nature, and we on more than one occasion have decided it's time to send something to the BPR or to the Board of Judicial Conduct. And, fortunately, those instances seem to be few, but a few is still too many.
Right.
We want to try to do the best we can to foreclose that, which is, again, part of the reason for the emphasis on that in the order.
And you mentioned in your introductory remarks that the order from Tuesday does include that judges and attorneys have an ethical obligation to adhere to the written plans and orders of the court. Has the Supreme Court considered what the ethical reporting duties might be for attorneys who observe other attorneys and litigants failing to follow the orders of the Supreme Court?
I won't say that we've had a full-blown discussion on that. Certainly we recognize that that's an issue, and I'm a little hesitant to say definitively what we feel like that is, because obviously that could ultimately come to us through a disciplinary matter. So I guess I would just say it certainly has not escaped us that regarding the ethical obligations, but I'd be a little hesitant to specify exactly what and we certainly have not actually come forward with the policy on it.
All right. We had a question about whether a clear plastic face shield that is open at the bottom without a face mask is considered a proper face covering.
The Commissioner of Health has advised us that face masks, shields are not a substitute for masks. So I think the answer to that is no. They really do. If they're using a face mask, a shield, they should also be using a face mask.
All right. We've got a question in the chat regarding mask mandates, and of course there are people who have differing opinions on mask mandates and the effectiveness of masks. If a member of the bar wants to bring conflicting evidence about mask mandates before the Supreme Court to discuss whether masks should be mandated, how would that attorney go about that?
Well, certainly they can work through Rachel Harmon and see, provide Rachel information that she can pass on to us. If they want to go so far as there is a petition process in front of us, but that normally takes some time. But I'll just say that we have looked very carefully before we did that because we realized it is an imposition. And certainly wearing a mask doesn't insulate completely people from testing positive. We see that day in and day out. But it's a little hard to ignore the evidence of when mask mandates have been in place that there are fewer cases. And there also are indications that it may tend to help mitigate the severity of it and all. And I guess the bottom line is the masks are not for you as an individual. The masks are for other people. And I hate those things with passion. But if it prohibits even one older person or one person with chronic conditions from getting that, it's hard for me to say that that's that much of an invasion. I just think that this is a tough time. We're in uncharted territory at all. None of us ever thought we'd be doing this. I certainly would agree. I, for one, never thought about my mask. You got to be kidding me. And obviously, to begin with, the science said don't wear masks, that they can be counterproductive. But that has changed now, and I think we have to be willing to sacrifice a little bit. And again, not for ourselves. That's not who that's intended to protect. It's intended to protect your mother, your father, your brother or sister who has chronic conditions. And maybe, we won't know for sure that that's the case for now, but is it that hard for you to try?
I agree, Your Honor. This next question is one that might have been addressed by the order, or I hope it's been addressed by the order, but someone asked, doesn't the reopening plan require courts to restrict the maximum capacity to 50% of the total number of people a courtroom can accommodate as long as social distancing measures are strictly followed? I was in a general sessions court civil this week, and we were packed in there like sardines, not only in the courtroom, but in the hallway and out in the seating area in the main lobby. So hopefully the new order will address that.
Well, the continuing orders have been that that's the limit, and there should not be more than that going on. In fact, I know we were not aware until literally this week that the general sessions courts in Knox County had to go back to their regular courtrooms and were not being able to use the assembly room, which they had been, and which was actually still a part of the approved plan for them. So Rachel Harmon has worked through Judge Green as the presiding judge, and I think that's being remedied very, very soon here, and they'll have access to the assembly room. But no, that's not acceptable. Never has not been since March, and it will not. It is not now. And we have seen instances of that occur. And Rachel has addressed the situation with some judges. And as one of the first questions you read, Hanson, noted, the overwhelming majority of our judges are doing it right and concerned. But we still have an obligation to address those few that, and whether it be good intention or not, in really trying to keep the dockets current, because there's certainly a problem there. Fact of the matter is, you just can't do that in today's time, and the order doesn't allow you to do that.
As you mentioned, Chief Justice, the restriction on jury trials that was in place earlier and is now in place again has obviously created a backlog in the courts. Has the Supreme Court talked about ways to deal with that once the floodgates open, hopefully sooner rather than later next year?
We have had some discussions about that, and what we would hope to be able to do, although we certainly don't have a plan with it, all is to utilize retired judges, if possible, to help us come in and sit specially to help with some of the backlog and address that. What that brings up, though, is the question of funding. And that's one of the concerns we have. And that's one of the things we're working on now is, fortunately, the great overwhelming majority, so many people don't realize this, the overwhelming majority of states, judiciaries, have not received any CARES Act money that was passed, regardless of what's going on. Now, let me give Governor Lee and his administration credit. Very recently, we've begun to receive funds from the CARES Act. So that's helping us. It's certainly not covering everything, but it's that type of a funding issue that once the dam does break and we're back trying to catch up on these dockets, we're going to need the ability to be able to use funds to help us address that backlog. One of the things that I've been involved in over the past several months is I'm currently serving as the chairman of the Government Affairs Committee of the Chief Justice's Conference of the country. And our major priority recently has been trying to work with Congress to assuming we ever get another COVID relief bill, that there is included in that some funds designated directly to state judiciaries. And what we're asking for is, it's not just now, but for a grant program to be set up over a 3-year period, which will help us have the resources to address these backlogs when they occur. Whether we'll be successful in that, I don't know, but it is a critical issue for us, particularly with state budgets the way they are now. We've been fortunate in Tennessee that the impact has not been as heavy as initially predicted, but it's obviously still there. So the thought of large funds being available to go forward is problematic at this point at the state level. So if and when there is federal legislation, we hope that we address that. But it's an ongoing problem, but we'll try to do that. The Alternative Dispute Resolution Commission has also been very helpful in developing a plan that they would put in place that will try to address mediation as an alternative in trying to help with backlog once it gets resolved. But it's going to have to be a multifaceted approach, and so much of it is going to depend on how things develop as we go. But it's going to be an issue that we're going to have to confront, and we continue to monitor it, and we continue to have communications with other states to see what they're doing. But hopefully, at some point, we'll be able to address it in a way that will ultimately get us back to reasonably current dockets.
Should I warn any retired judges I know that they may be pressed into service?
That's right. They may need to dust their robes off.
Your Honor, we have a question in the chat about some attorneys are concerned about relying on Governor Lee's executive orders allowing remote witnessing and notarizing for execution of wills because they question whether the governor by executive order may relax statutory requirements for will execution established by the General Assembly. Please speak to this.
Well, certainly, I mean, I have to be careful in the standpoint of there could, I suppose, be ultimate challenges that come before us with regard to that. But I will say generally that the powers given by the legislature to the governor for emergency purposes is very broad. And that's by statute that they've done that. Now, I think the legislature is looking, they may choose to limit that in the future, but for now, that's still there. And that's what the governor has relied on in many of his executive orders. And I will say that we did try to work with his office in crafting language that would be helpful because we initially were apprised of the situation of the notary issue, which came in, but then it also became clear that, particularly in a will situation, that it's not only a notary issue, but it's a witnessing issue as well. So, hopefully that can be addressed. Certainly, if anyone wants to be overly, certainly very cautious, they could try to redo those once in person is available. But at this point in time, to my knowledge, we've seen no challenge to that authority certainly for that particular order.
All right. The order issued on November 17th, which suspends all jury trials from November 23rd through January 31st, also mentions that there are exceptions which may be granted by you as Chief Justice on a case-by-case basis. Our Knox County judges have taken measures to be able to proceed with 12-person juries in both criminal and civil cases, including moving furniture around the courtroom and installing plexiglass around the witness stand so that a 6-foot distance can be maintained at all times between everyone in the courtroom, and other CDC recommendations can be followed. Thanks to the hard work of our local judiciary and court staff, both our criminal and circuit courts have successfully proceeded with 12-person jury trials in recent months following these recommendations of the CDC. If both parties and the trial judge are all comfortable that CDC recommendations are being followed in the courtroom and they wish to proceed with a jury trial that is currently
Hanson, you've frozen on my screen. I can't hear you at the moment.
Why don't I pick up, let's see.
You can still hear me, correct?
Yes, I can hear you fine. So let's see. So Hanson was talking about the, thanks to the hard work of our local judiciary and the court staff, both criminal and circuit courts have successfully proceeded with 12-person jury trials. If both parties and the trial judge are all comfortable that CDC recommendations are being followed in the courtroom and they wish to proceed with a jury trial that is currently scheduled during the suspension period, do you suggest that the parties and the trial judge jointly apply to you for approval of an exception?
They certainly can do it that way if they want to, but I think you have to remember there's another part of that puzzle that's a very important part here, and that's the jurors involved. And I think we're seeing much more hesitancy amongst potential jurors to come in for jury duty and things of that nature. And obviously in this day and time, if someone is subpoenaed for jury duty and they have valid COVID concerns, certainly judges are not going to sanction them for that. So I think we have to balance that aspect of it. Certainly the way we phrase the order, it's not envisioned that business can continue as usual in that regard. What that really was intended to do was to address those issues where there are very old cases that need to go forward. There are particular circumstances that address that. For example, one of the trials that I think we will ultimately end up letting move forward is a trial out of Madison County that is a medical malpractice case involving the death of a child that is scheduled to go for 3 weeks that is now 20 years old. And there are witnesses scheduled in from out of state, things of that nature. So that's the type of unique situation that I think we're looking at. Certainly, we will take a look at any exception request we get, but I will say it's not intended to be business as usual.
I apologize, Your Honor, and Marcia.
That's quite all right. I understand.
Welcome back.
My computer just went black. It has not done that before. That's a new one for me. But
I had that happen to me very recently in a panel I was participating on too. It's the first time I've ever done that. So
I think we're testing all of our equipment quite a bit this year. So I was in the middle of a question that was dealing with the process for granting exceptions. Did you speak to that while I was gone?
yes, Marcia was kind enough to jump in and finish up the question. And that's the question I was answering when you came back on.
Thank you. And Marcia, you might let Tammy know there was a question in the Q&A about depositions that now that I've restarted, it no longer appears in mine. So if she could send that to me through the chat, I can ask the Chief Justice about that. Your Honor, one of our members sent in a question about the fact that number 6 in the order mentions that participants in a proceeding who have tested positive for COVID-19 shall not appear until they've strictly complied with the requirements of CDC. And someone in our audience wants to know, why are persons who are also subject to a quarantine due to exposure not also prohibited? For example, the Blount County Standing Order prohibits not only people with a positive test, but also those quarantining or awaiting the outcome of a screen from attending court.
Well, certainly the order was not intended to address every circumstance that was out there. We had to try to put it together in an expedited way to try to get some additional guidance out there as we go into the holidays. It's certainly not our intention to say it's okay to come into the courtroom if you should be under quarantine in that situation. Of course, one of the difficulties you run into is the CDC guidelines have changed from time to time as to what type of exposure is necessary to trigger the quarantine requirement. So you do get into that issue of, well, is because someone was in the same room with somebody else, is that enough? So it's a difficult, and that is part of the reason we certainly hope that the local courts are addressing those issues. I think the Blount County order is a perfect example of that, and certainly it is a good approach to that, because we at the Supreme Courts can't monitor who should be in quarantine and who shouldn't. But the fact that that's not a part of the order should never be interpreted as saying it's okay to show up in those situations.
And it's obviously impossible to really have a one-size-fits-all approach when different courthouses have different physical layouts and things of that nature. Another member asks, Your Honor, approximately 1/4 of my child's school is quarantining due to exposures as of Wednesday. How does the court plan to address this as quarantines rise for litigants, court reporters, attorneys, staff, etc.? Third-party childcare cannot be utilized for a quarantining child, especially for young children. We need guidance for the courts in these scenarios, and video hearings will have to be utilized in many scenarios to avoid continuances.
Well, that's exactly what the order says, is that there's a continuing emphasis on that. We're going to continue to reemphasize that to our judges, that it's the preferred way of conducting business now. It's still by video conferencing. And it's certainly a good example of when that needs to take place in that regard, because it's so difficult on a single parent or parents with both parents present when a child is under quarantine requirements or being taught virtually as is happening in a number of counties. So that's the type of thing we are going to, again, reemphasize that. We have, again, stressed to our judges that if you need something as far as the capability goes, let us know. We're also going to be having additional training take place for the use of Zoom. I think we have enough Zoom accounts now that's not an issue, but if we need more of those, we can do that too. But it certainly is an issue, and that's in large part what we want to emphasize as part of this last order is, let's not get away from the things that have worked, and so many judges have done a great job in utilizing video conferencing so far, and that needs to continue to take place, and in fact take place more often than it is now.
All right. Tammy has texted me a picture of the deposition question that disappeared from my Q&A. So we're as all the courts are across the state, we're just trying to make it work any way we can.
Exactly.
This question is, has the court considered how to modify depositions in addition to in-court proceedings? Could the court consider requiring remote or video depositions, or at least require masks and social distancing for all depositions? Some attorneys still think it should be business as usual with 9 people crammed all day in a closed conference room without masks. Currently, we have nothing from the court encouraging anything different during the pandemic.
Well, again, it's certainly not our intention to have that type of a situation taking place. We would hope that could be managed at the local level and address that with the local judge, because again, you have so many different instances about exactly what that is. But I mean, to the extent that that needs to be encouraged, we certainly would encourage, and I mean, as a part of that, and that certainly needs to be taking place. And the great majority of deposition could certainly be done by video conferencing, and they ought to be doing it that way. So I would hope that, if there's a particular issue, take that up with your judge, and then if that's not satisfactory, they can contact the AFC.
All right. Someone else asked about pro se litigants are afraid to stay away from court and have no one to communicate with before they attend. Can there be a quick modification on all summonses stating a phone number to call if they have COVID or are CDC exposed and a directive not to attend?
Well, I don't know that we could actually change the summons form itself, but certainly clerk's offices, and I think some clerk's offices are providing information as far as contact information and that type of thing. So hopefully and I would encourage folks, if they have an issue, to talk to your clerk's office, talk to clerk and master's office, to whomever, and try to see that they do have something set up where people know how to contact folks if there is a problem. All
right. We got another one through the chat here that is about the procedure for requesting an exception to the jury trial prohibition. It says the order does not indicate the procedure for requesting the Chief Justice to consider an exception. Do the parties need to prepare something formal for the court? Do you want the parties to send the request to you by email? How would you like to receive such a request, and what information would you need to consider it?
Well, the request, I mean, it can be joined by the parties, but it needs to come from the judge. And the judges have been instructed that we did a follow-up email with the judges with the order, which gave them the email addresses for my 3 staff members that are looking over, that will be directly responsible for going over those. But certainly, it's still, because the judge needs to be involved in it too. We don't need the parties just asking for it. So as far as the information goes, we need to have as much information as you can give us as to what makes this case somewhat unique and how problematic it would be to reschedule it for later. What's the prejudice to the parties? What's the witnesses' availability? The more detail, the better as far as that goes.
All right. This is another one we received before the most recent order was issued, and so it may have addressed it, but there's an aspect to it that I may add to the end of it here. The question was, when the initial order suspending trials occurred in the spring, there was much less COVID cases than the current rate. There are many members of the bar in their late 60s and early 70s who practice regularly in court. Has the Supreme Court reconsidered the calamity of the pandemic on the senior members of the bar that are under court order to try cases that might last more than 2 days? Is it reasonably foreseeable the court will extend the suspension of court proceedings particularly among those who are at a higher substantial risk of infection, and that risk of infection is dangerous to the point of death. Now, obviously, the most recent order answers several of those questions, but that question put in my mind asking if the court has considered the disparate impact of the pandemic on certain members of the bar versus others. For example, the science has shown that older people may be more susceptible to the worst parts of this virus. Has the court given any consideration to that when looking at how this will affect older attorneys?
Well, I mean, we certainly had those discussions, and I would never want to de-emphasize the importance of that. But, you know, we also have younger folks who have pre-existing conditions that make their exposure very problematic as well. So we have tried to take the approach of not curtailing it for particular age groups or things of that nature. But the overriding factor should be complying with CDC guidelines here, recognizing that that's part of the facial coverage requirement that's out there. And certainly that's part of the emphasizing of the video conferencing and teleconferencing that the judges need to be doing. So there's certainly a large part of what's going on out there, or what needs to go on out there, can be done by video conferencing, or a lesser preferred instance of teleconferencing. But those things need to be handled. But it's difficult to do that again on a statewide basis.
Right. Your Honor, we had a question through the chat about law school graduates. What are your thoughts on the pandemic's impact on recent and future law school graduates, including the Tennessee Supreme Court's denial of diploma privilege, exam date delays, the remote administration of a non-uniform bar exam, resulting financial struggles, and future employment opportunities?
Well, it's certainly been a very difficult time for law school graduates during this. And while it may seem stressful, and they may not agree with the approach the court has taken, we have tried to balance those issues. And it's been hard on practicing attorneys as well in how to handle things. So we have tried to move forward in having something there, but yet also not simply opening up to diploma privilege. And folks, diploma privilege sounds like an easy concept, but when you look at what it's been, where in the very few states in which it's been adopted, if you look at how it's been adopted, there are several restrictions on it. For example, in the state of Utah, there was a provision that says we'll grant diploma privilege for any graduates of any in-state law school that have a bar passage rate of 85% or better. Well, trying to set that type of an arbitrary guideline is difficult. And the court also has an obligation on the other end to protect our profession. And the great majority of law school graduates are certainly entitled to practice and will practice. But sometimes there are issues that are there that need to be looked at. As far as the remote testing that took place earlier in October, while I think the reference was to a non-uniform approach, that test was developed by the National Conference of Bar Examiners, who also develops the uniform bar exam. And that's who developed it. And while it was not a full test, it was sponsored by that organization. It was developed by them. It was, the validity of it was tested as it should have been. But most importantly, what we did and what was worked with a number of states, and I can't remember the exact number now, but it was well over 10 states that got together and signed a memorandum of understanding that they will recognize those scores in those other states. So it's the equivalent function of a uniform bar exam being able to be transported across state lines. And there are a large number of states that are recognizing that. Again, is it a perfect solution? Absolutely not. But it is a balancing of those interests in going forward. And we certainly hope that, it's a compromise that is ultimately the best we can do in a tough situation.
One question I had, Your Honor, was about whether the court has considered extending the lifted restriction on distance learning for CLE. Has the court considered that?
The court is definitely looking at that, and I would anticipate you hearing about that in the very near future.
All right. If any of our audience members have any questions, we do just have a couple minutes left. And I was curious, Your Honor, once we do get jury trials going again, how do you feel? And I don't want an advisory opinion or anything like that, but do you have concerns about jurors wearing masks or witnesses wearing masks or jurors seated in non-traditional locations in the courtroom where they might not be able to see as well? Has the court considered these types of issues?
Well, we have had discussions about those types of issues. And you're right, I have to be careful about what I say and what I don't say. But I do think that extraordinary times require extraordinary measures. And if that's what it takes to allow the trials to go forward, then that's perhaps what we need to do. Particularly in the criminal court context, balancing that aspect of it with the right to a speedy trial, and particularly if that criminal defendant is sitting in jail during that time, then it's very problematic to not go forward. And if those type of steps are what it takes to allow us to move forward under these extraordinary circumstances, then sometimes those may be a necessity.
All right. And I'm not seeing any more in our Q&A here. We spoke before the program began, and I had asked you about, do you know how many jury trials we've had since March of this year, both civil and criminal? And I was surprised. You said you didn't have the exact number, but I was surprised at what you said. Can you tell the audience?
Yeah, I feel certain we've had at least 10 to 15 jury trials across the state. We have seen, I think Knox County has obviously done a good job in trying to move forward with that. I think they may be the only metropolitan area or urban area that's gone forward with that. Chattanooga, I think that Chattanooga might have, I'm not sure. But I know Nashville and Memphis have not. But there have been a number of trials that have taken place in some of our rural counties, more rural counties, because in some instances they may have very large courtrooms, and they can do that. Another example that I have used, and I can't remember if I mentioned it in this open setting or not, was the situation where Judge Mike Spitzer down in Lewis County went to the National Guard Army and selected the jury selection there, and then went back to the courtroom to do that. And I think we've had other judges who have utilized somewhere with a larger location to do that, which allows some more flexibility. So I think we will try to see what's that, but that's kind of what's happened so far. And we've also asked those judges who have been able to hold jury trials to provide and share the information with the other judges as to what went right, what went wrong, how it can be improved, things of that nature, so that throughout this entire time we have continued to have very frequent communications amongst the various judges. For a long period of time, I was having phone conferences weekly with trial judges on one call, the general sessions the judges, and sometimes and juvenile judges being involved in that in some instances, and also on occasion with the municipal judges. So we have tried to keep that type of communication going. The AOC has provided the judges with information that's been shared with them by way of the jury trials. So we continue to try to share information. We continue, as I mentioned earlier, to work with and utilize what other states are doing. The National Center for State Courts has done an excellent job of putting together webinars addressing a number of these issues and having a pandemic response team that's jumped on these things. So it's a multifaceted approach that we're trying to move forward with to hopefully get that number up of jury trials ultimately, obviously not for the next couple of months.
All right. We do have one more question in the chat, and we can wrap up with this one as we're getting close to the end of our hour here. The question is many at-risk attorneys are concerned about facing disparate treatment if they request a proceeding to occur via telephone or video conference if the court is willing to hold in-person proceedings in spite of that court's ability to conduct remote proceedings. What should an attorney do who wants a hearing to be held remotely, but opposing counsel or the court wants it to be in person? Is there an appeal process if the remote request is denied by the trial judge?
Well, I suppose because I think those are two separate questions. If the opposing attorney wants it and whether the trial judge orders it. Certainly, if it's the opposing attorney, you need to go to the judge.
Right.
If the judge is doing it, there certainly is a Rule 9 or a Rule 10 appeal process that's available. You can also, again, perhaps contact the AOC office, and we can try to informally address the issue and see what the approach is, and perhaps encourage the use of alternatives to in-court proceedings.
All right. Well, Your Honor, you mentioned earlier at the beginning of the hour that one of the unfortunate effects of this pandemic was having to cancel the Knoxville Bar Association Supreme Court dinner. I was very much looking forward to that, not only to hear Coach Barnes speak, but to also honor and thank the Tennessee Supreme Court for all the work that you do every year. But this year, more than any other, the work that you've all done to keep the courts open and to keep us all working and to keep the justice system going. And so please express our thanks to the rest of the Supreme Court. We've had Justice Lee on for a town hall several months ago, and we asked her to thank you as well. So please express our thanks in this time of Thanksgiving, and thank you personally for spending this time with us. We really appreciate all that you're doing for the courts and for us as lawyers, and we thank you for your time here today. I will remind our audience members that the annual meeting and election are coming up, so please check your email or your mail for information on how to attend that. That will be done remotely as well. And the online CLE catalog is open and available for everyone. And as Chief Justice Bivins mentioned, we may be continuing online CLE for the foreseeable future, but we'll be hearing about that from the court soon. So once again, Chief Justice Bivins, thank you so much for joining us today. Thank you for your time, and we appreciate all you do for the state of Tennessee and for our local bar.
Thank you very much, Hanson. It's been a pleasure to be with you, and certainly I hope that it's in the not too distant future we can begin to see each other in person again, because I truly miss being able to do that. I love getting out with the interaction. Over the past couple of years before this happened, I had put 30,000 miles traveling in my car, traveling across the state, going to various locations to see people, to meet people, to speak to people. And I miss that. And I think that's something that helps us keep in touch. So hopefully we're doing the best we can, but I do miss that. I hope we can do that again. And I appreciate your leadership as well. And I appreciate Marcia and the entire KBA staff for what they're putting this together. And thank you for having me.
All right, thank you. Happy Thanksgiving to everyone. Have a happy and safe Thanksgiving, and have a good weekend, Your Honor.
Thank you very much.